Hello, everyone, and welcome to today's webinar, an overview and preparation for the California Consumer Privacy Act. I'm excited to be here with you today. My name is Greg Sparrow. I'm Senior Vice President and General Manager here at Compliance Point. For those of you not familiar with Compliance Point, our company specializes in information security and risk management services with a focus on data security, data privacy, and compliance. We've got two great speakers here with us today to speak to you on this topic. We've got Matt Dumiak here from Compliance Point, as well as Matt Sullivan from Kelly Dry Warren. Matt Dumiak is the Director of Privacy Services here at Compliance Point. He's focused on both U.S. and international privacy regulations. He works with clients across a variety of industries and is dedicated to providing reliable and practical consulting recommendations. Matt holds multiple privacy certifications for both Europe and the US from the IAPP. Matt Sullivan is a senior associate in the Washington, D.C. office of Kelly Dry Warren. Matt represents clients in all forms of privacy and data security matters, from counseling and transactional support to data breach response and mitigation. He also helps defend federal and state regulatory investigations. Matt also holds his CIPP US certification from the IAPP and is the Vice Chair of the American Bar Association's Privacy and Information Security Committee. Before we get started here, just to cover a couple of housekeeping items, you can submit questions anytime via the chat window. We will be watching for those, and we will cover and respond to those after the presentation has completed. We will also be emailing out a copy of the recording of this presentation based on the email address you used to register for this webinar. So without further ado, I'll hand it over to Matt Dumiak.
Thanks, Greg, for the introduction. And for anyone who's listening, I know we have two Matts on the webinar today. The voice you hear today right now is Matt Dumiak, and then you'll hear from Matt Sullivan shortly. So I'll just handle the agenda and then we'll dive right in. So first and foremost, we're going to handle or review the CCPA, a little background on how it came to be through the cocktail party and things like that. I know that everyone has most heard that story, so we won't spend too much time on that. Really, the meat of this presentation will be reviewing the requirements under this regulation and then our recommendations for complying with it on an operational level. So more so some pragmatic or practical things to think about when you're getting ready or preparing for this regulation. Then we'll jump into the CCPA proposed amendments as they stand today, and then some other state level moving targets that we thought you should be aware of just with the privacy wave here in the US, on the horizon. And of course, throughout, we'll be answering questions through the chat pane, and we've reserved some time at the end of this presentation to answer some questions that are posted in the chat that we do not get through while we're presenting. So with that, I will pass it over to Matt Sullivan to provide us with an overview and background of the CCPA, and then we'll dive into the operational side. So Matt, on to you.
Thanks, Matt, and good afternoon, everyone. It's nice to be part of this webinar. If you've joined this training, then you know about the CCPA, and you may be familiar with the story that has now become part of Bay Area legend, but it bears repeating because I think the background is helpful to understand why we have the law that we do. It's probably safe to say that any law that originates from a discussion at a cocktail party is going to have some quirks to it. The CCPA certainly does. This was really the brainchild of a real estate developer who had a discussion about the amount of consumer data that's being collected and how that data is being used. And this developer enlisted some contacts in Sacramento who drafted a ballot measure that was going to be extremely burdensome, if not impossible to comply with for companies. And he enlisted a lot of resources to make sure that that measure made it onto the November 2018 ballot. Because of the concerns, and particularly the concern around the difficulty in amending a measure that is passed through an election process, the state legislature then stepped in, and they made a deal. if he would withdraw the measure from the ballot, they would pass this as law with minimal changes. And that's exactly what happened. It passed within a matter of days. The most concerning thing is that there was very little in terms of industry, public, or consumer input. And as a result, we have a law that has typos being one of the smaller issues, but just some provisions that simply don't make sense. As we'll discuss, there is some cleanup expected to take place to the law over the next year before it goes into effect on January 1st, 2020. But it's very difficult to say at this point what kind of relief businesses may get based on the anticipated changes to the law. All right, so in terms of who has to comply with the CCPA, the short answer, if you are doing business in California, you probably do. It applies to for-profit companies, so nonprofits are exempt. And those are companies that are doing business in California. They're collecting personal information from California residents, and they're determining the purpose and means of the processing. So that sounds very much like a GDPR controller definition right there, but it essentially means that if you are collecting personal data and you're deciding as a company what to do with it, then you've met the first prong. You're halfway there to having to comply with the CCPA. There are a few other factors that also would trigger jurisdiction of CCPA. One is that your annual gross revenues are in excess of $25 million. That is going to bring in a lot of companies that are going to have to comply with this statute. There's also the element of deriving 50% or more of your annual revenue from selling PI. That will be applicable to significantly fewer companies. And then there's this middle bullet here. So it's companies that annually buy, receive, sell, or share the personal information of at least 50,000 consumers, households or devices. That may sound like a lot, but if you do the math, that's about 136 pieces of information that you would be collecting per day. That's not a lot. So again, a lot of companies across all industries, not just technology, will have to comply with this statute. So what does the law do? It was intended, or it is intended, to give consumers a series of rights. And we'll talk about each one of these in more detail as we get into the presentation, but it really breaks out into three separate buckets. The first bucket is around transparency. So it's telling consumers what types of information is being collected about them, the personal information, what information that the companies that have collected, that they have then sold to a third party, and then also giving individuals the ability to access the specific types of personal information that a company has collected about them. That's our first bucket. The second bucket is around choice. There's a right to be forgotten, also known as the right to deletion. So a consumer can make a request to a company asking them to delete the personal information that they maintain about them. And then there's a right to say no to the sale of personal information. So if someone has provided information to a company that's being sold to a third party, they can make a request to halt that further sale. And then our third bucket is this bottom right box here, the right to be free from discrimination after an opt-out. Some gray area around this one. We expect that we will get more clarification in the regulations that will be passed as required under the statute over the next year plus. But essentially what it means is that if a consumer exercises his or her rights, a company cannot penalize that consumer for that. They can't automatically charge them more, refuse to sell them certain goods or services. And again, we'll get into more of that as we go through the deck. So on paper, these rights sound reasonable. So why all the fuss? And as mentioned, there has not been a lot of public vetting or industry vetting of this statute before it was passed. So what we've ended up with are some very broad definitions that go beyond, and in some cases far beyond, what we see in other privacy laws that companies are working to comply with. And I'll give a couple of examples. The definition of personal information. This goes far beyond what we typically think of as personal information, personally identifiable information. And it includes, if you look at the language there, information that is capable of being associated with an individual. Well, that's a very, very broad term, and potentially the way that companies would need to look at that is any information that they collect about an individual is capable of being associated with them. There's also this last part there, the parenthetical, inferences drawn from such data. So it's not only the data itself, but it's what types of decision-making inferences that a company might be making based on that data. So again, very broad definition of personal information. I'll skip down to sale there. And again, this goes beyond what we traditionally think of as a sale. If you look at the last part of that definition, it includes both monetary consideration and other valuable consideration. Not exactly clear what this means, but what it will require companies to do is a case-by-case analysis of the information that they are passing on to a third party and taking a look at, are we getting anything back that could be considered valuable consideration, and therefore is that considered a sale of that information? So this is our starting point. We have a law that presents some very distinct compliance challenges, in part because it's very broad and not especially well written. And I will now turn it over to Matt so that we can just start beginning the conversation of how we tackle some of these provisions from an operational standpoint.
Yeah, thank you very much, Matt. That was a great overview of kind of how we got here and where we are thus far. So, moving forward, I think this will make a lot of sense, but just the structure of this presentation and how it will flow is I'll be going over the operational considerations, but before that, Matt Sullivan with Kelly Dry will be giving a little more of the legalese background on a requirement, and then I'll be talking about how to handle that and some things to think about as an organization as you go through this journey. So we can move to the next slide. And thinking through that, one of the common questions is, where do we start? So how do we begin reviewing this regulation? How do we understand it applies to us? How do we get started? And so it's a California regulation. I think it makes sense that you start with California data, that the personal data that is within scope of your environment. So the California personal data that you're processing, that's where you really want to focus. Many of you who have been through a GDPR exercise may have tackled the GDPR by focusing on EU personal data. Some of you may have said, you know what, we're going to make this a global exercise. We see it coming. At that point, you likely do have, an inventory and a map of all the personal data within your organization, and that's great. So you can start from that. The CCPA borrows some things from the GDPR, but they are not the same. There are some vast differences, as Matt has already reviewed, and so you'll want to ensure you account for that. Next, looking at this, it's consumer and employee-facing activities, and why we take that approach or make that recommendation is because these are the areas where consumers and employees on the publicly facing the publicly facing areas, they can check very easily if you're complying with the regulation or if you're ready with the regulation as a company. So they can go read your privacy policy. Are you making the required disclosures under this regulation? Do you have an opt-out link if that's required? Can you honor or do you respond to consumer privacy requests, things like that? And we'll walk through this, but it's with mapping, handling the consumer privacy rights, website updates from a notice requirements in your privacy policy or wherever else that might be required on your homepage. And then, of course, more so in the background, but something that takes a little more time to get in place if you don't have anything, is ensuring that you have appropriate technical and security controls. And the reason we say that is because, again, that typically is a little bit longer of a roadmap on the technical and security controls, but it does help to prioritize. While I wish that we could prepare for and be ready for any regulation in a day, we understand that that's simply not possible. So we broke the requirements into seven separate buckets, just to keep it, more straightforward and simple. But we'll be reviewing, where to start with the data mapping and inventory, some practical recommendations about how to approach that. Again, those of you who have undergone a GDPR exercise will be familiar with this, and it could be as little effort as expanding the scope, or it could be leveraging what you've discovered thus far within your exercise. Then we'll talk about your website updates. So what are the requirements around that? And then things to think about when you're going through that exercise. The right to equal service. So this is the right to not be discriminated against. consumer privacy request design. So this is going to be important, and this is something where those consumers can test you to see if you're ready for this regulation by requesting right to access or to be deleted. Opt-out management, and what we mean by that is when a consumer opts out of the sale of their data, how do you handle that? How do you manage it? Kind of some pragmatic approach or recommendations towards that. Of course, just general policy development and updates. We always preach that you don't need to reinvent the wheel. You may have some policy or a governance layer that already exists and speaks lightly to these privacy regulations. Maybe they just need to be put more so within the context of CCPA. So leverage where you can. But frankly, this is a fairly unique regulation, as we've already reviewed. And so there will be some new policies that you need to update and approve. And then breach response, of course, at that point, there's a process and a requirement under this regulation that consumers can file a private right of action if they feel like they have been impacted by a breach of their personal data. So how are you going to receive those? How are you going to handle those and ensure you can defend yourself against that? So we'll start now with the data mapping and inventory. So jumping into the data mapping and inventory, as you'll notice, we don't really have a requirement slide per se for this. As you'll see for the rest of the presentation, we do have a requirement, a area of the regulation, and then what's required, and then we'll handle the operational approach. But with data mapping and the inventory, this is not an explicit requirement under this regulation, but I think that it makes sense to go through this exercise in order to determine the scope of your obligations, where does the personal data reside within your environment, how will you honor the rights. As you'll see, the data mapping and inventory will really be the foundation of your privacy or data protection program. And so this is how you will know where your obligations are, where your personal data resides, and how to comply. Some things to think about when you're going through the data mapping and inventory exercise. Occasionally we'll work with clients, especially in the beginning. They see it more so as an IT or a legal exercise. I'd really like to stress that this is an enterprise-wide exercise. You will need input from the business side of the operations. This can become a more technical exercise once you do a deeper dive and really need to know where that data resides within your environment, how long it's maintained, some other things. And then, of course, this is a regulation. You will need legal sign off on the scope of personal data within your environment, and some other things that they will need to approve. So again, it's going to be a cross-functional team. I'd really recommend that through the data mapping and inventory, this is where you really want to establish your privacy team, if you will, in order to help with this. Also, there is no silver bullet for data mapping and inventory. We find that it is typically a combination of people and technology. There is plenty of software out there to assist you with it, absolutely. And that's something you will need to leverage more than likely. You can leverage, there is scanning software available to find where the personal data is within your environment. At that point, what you'll need to do is perform the scan, find the data, digest that, determine what it means to your organization, and then leverage data mapping technology to map and inventory that as well. And then as well, people, like we've said, you're going to need insight from the business. You are required under this regulation to outline to people who you're sharing your data with, what purpose, some other things like that. That type of insight comes from institutional knowledge from the employees at the organization. And again, so the data mapping, the inventory, it really does serve as that foundation for your privacy program and ensures that you can meet those obligations on a go forward, and also assists you with establishing, preparation for this regulation. If it's a project schedule or a project plan, if you will, and how to comply, and that'll really give you that picture of that. And so when you're building your mapping and inventory, some things to think about are, on a personal data level, make sure that you categorize that personal data. So the types of personal data you're collecting, for what purpose, why are you sharing it, the organizations you're sharing the data with. And this is something that if you've gone through the GDPR exercise, you're likely very familiar with the data mapping and inventory and tired of hearing about it. But with CCPA, as you're going through that, something that's going to need to be expanded through your data mapping and inventory that's unique to CCPA is classifying the companies that you're sending the data to as either a third party or a service provider. We'll go through that a little bit later in this presentation about why that's so important. But again, you'll want to ensure that from the business side, why are you sharing that personal data? That will likely drive if it's a third party or a service provider. I wouldn't think about the data mapping and inventory if you're trying to discuss this internally or get resources for it internally and externally as simply a means to comply with a privacy regulation, right? So this data mapping and inventory exercise can also assist you with realizing some efficiencies within your organization. We have done data mapping exercises or data inventory exercises with organizations that were leveraging 6 to 7 different email service providers. They had no idea because they had a very entrepreneurial approach towards business development, and they didn't realize that all these different departments were utilizing different email service providers. So it could be a chance for the company to look at this and say, you know what, we could realize some efficiencies, some cost savings, and it's easier to manage because the systems are all the same if we cut down on the number of service providers we're using who are providing us with the same service. And so that's possible as well. Once you know where the data is flowing, how it's flowing, and where it resides within your organization, at that point, you can ensure that you have the reasonable security controls around the personal data and to ensure that you can defend yourself against any breach claims, which again, we'll go over that process later on in the presentation. So this is a sample data map. I think we just like to include this because it really highlights that data maps come into many different shapes and sizes. We've talked about it. There is no silver bullet. However, the data map, this is a relatively simple one, but just like to give an example of what that exercise can look at. And it's tracking, for example, the format of the personal data, its audio, paper, electronic, where some high risk areas might reside, ingress and egress points. So both where you're getting data directly from the consumer, so notice requirements are required, or where you might be sharing that with third parties or service providers, whichever you determine they might be. So next, going through the website updates, and this is where I will pass it back to Matt Sullivan to go over a little bit about on the privacy policy disclosures, what's required, and then I'll jump back into how we recommend making those updates on your website.
Great, thanks, Matt. And just one follow-up point on to Matt's discussion on data mapping. And I think he made this, and I'm just going to put an emphasis on it. We see all types of data mapping. There are technical means to do it. Some companies will, depending on the scope of data collection, will just do interviews and write up a summary based on the discussions with different departments that have access to personal data. The key is not to let the perfect be the enemy of even the adequate. It's really just to, it sounds daunting, and it can be, again, depending on the organization, but it's an important, really critical piece to get the ball rolling on compliance. So with that said, we're going to dive into some of the specific requirements within the CCPA. I mentioned earlier about the buckets that were part of the overall intent of the statute, and the transparency is one of the key objectives. What that means in practice is that you'll need to ensure that certain information is contained in the privacy notices that you provide to consumers. And this is not expected to be one of the heavier lifts for the most part under the statute, because there are already California law that requires companies to have privacy notices with a lot of this information in them. So if you think of the CalOPPA, the California Online Privacy Protection Act, that mandates a privacy disclosure on the website if you're collecting online data, and that you provide some of the information that you see here on the slide. But just to be clear, under the CCPA, there are specific disclosure requirements. At or before the point of collection of personal information, you need to make sure that the consumer has access to a notice that describes the categories of personal information that will be collected and the purposes. The time period that we're really concerned with here is within the past 12 months. And then moving down to that 3 lists, bullets there. So it's the categories of personal information that have been collected within the past year, sold within the past year, or if there hasn't been any data that's been sold under the CCPA's broad definition, it would be a need to include a statement that you did not sell personal data. And then the categories of personal data that has been shared within the past year, or a statement that the information wasn't shared. So this is something where The company will need to have some vigilance in making sure that this list remains updated at least once every year. Also within the privacy notice will need to be a description of the consumer rights under the CCPA, as well as 2 contact mechanisms. The obvious ones would be email and phone that would allow a consumer to exercise their rights under the statute. And then last, we'll get into this in a little bit more detail, but there needs to be a link that is expressly titled "Do Not Sell My Personal Information" that a consumer could click on within the policy to be taken to a separate page that will actually allow them to make a request to no longer allow their data to be sold.
Yeah, great. Thanks, Matt. Excellent overview of those specific requirements. And then from an operational perspective, I think that, as Matt has said, you're going to be required to make certain disclosures about the categories of personal data that you've collected, sold, shared. A lot of that will be derived from the map and inventory, which outlines, how you collect the personal data from the consumer, what data is actually collected, how it's shared, the purpose of that. Something to think through as well is if you are selling data, you will be required to have that opt-out link on your website. So functionally, how are you going to honor that request? Who's going to receive those requests? How will you, from an operational layer, go to all, internally and to ensure that you don't no longer sell the data, but then also go to those providers to let them know that you'll no longer be selling them data. As Matt has said, you're also going to be required to put 2 forms of contact in your privacy policy or on your website to ensure that the consumers can exercise your rights. So thinking through the training that's going to be required to ensure that your representatives on the phone are aware of how to handle these types of requests, as well as email, who will receive these emails internally, how will they be escalated to the privacy committee and reviewed for applicability, some other things like that. Something else to think about as you're amending your privacy policy, and I think is a best practice and something that is encouraged by regulators, is the layered approach towards the notice requirements. And so what we mean by this, and some very large companies like Microsoft or Apple take a very good approach at this, but they layer the privacy policy with only the applicable information, or the information, I'll say, that you are asking for as a consumer. So if you wanted to see the categories of personal data collected, you could click on a link and see that. You could see the categories sold of personal data by clicking on a different link. And if you think about that, that's where we get the term layered approach. It doesn't just throw it into a 15-page document at the bottom of a website. What it does is say, oh, would you like to know more information about how we collect your information, or why we collect it, or who we share it with, and for what purpose? At that point, you can click on those individual layered approaches, find a more direct answer for the type of information that you're looking for. Again, easier for the consumers to understand. And frankly, it can also help the organization clearly understand what they're doing with personal data. And then as well, from a website perspective, the regulators have written in that you are allowed to have, if you can take reasonable steps to direct the California consumer to this page, you are allowed to have a California specific homepage versus a site that rules them all. And so making some determinations around that, I think that will be really more of a philosophical approach towards privacy, as in what approach do you want to take as an organization? Do you want to make these types of rights and disclosures just within the website and then apply them as they come in from California? Or do you really want to funnel the California consumers to their own specific homepage where they can read about these disclosures and rights that they have under this regulation? And so next, we've gone through the data mapping and inventory, as well as the website updates. Now we'll receive an update or an overview of the right to equal service from Matt, and he can go over what's required, and we'll do an overview of some things to think about. But Matt, anything else to add about the website updates?
No, Matt, I think you covered that very well. And yeah, I think this is probably one, unfortunately, this is going to be one of the lighter lifts in terms of complying with the regulation.
Yeah, understood. All right, so moving on to equal treatment, we'll go to the next slide.
All right, so we're going to move into one of the buckets of rights that I had mentioned under the earlier slide, and that's this concept of equal treatment. And under the CCPA, companies cannot discriminate against consumers who exercise the various rights within the statute. So they can't deny them goods, charge different prices, offer something of a different quality to a consumer versus a consumer who is providing more data. However, under the statute, companies can charge different prices if the difference is reasonably related to the value of the data. And this is an area where we've got the gray area because we're just not sure what that actually means, reasonably related. Who's quantifying that? So this is a point that we think that when the AG regulations come out in July of 2020 or by then, we should get some more clarity on what that actually means. And similarly, companies can also offer financial incentives for the collection of personal information as long as they're being upfront with consumers and obtaining their consent for the collection of that data. So in practice, it's hard to say exactly at this point how this will play out and how this will impact different programs that companies have. But what it suggests is that if a company is taking unfavorable action directly in response to a consumer exercising their rights, then that would be considered discriminatory under the statute. But companies that have loyalty programs, that run promotions where they are collecting data and consumers get a special benefit for participating, that seems to fit in that second bullet there in terms of charging different prices or offering financial incentives that would be permissible under the statute. So at the end of the day, companies are going to have to take a case-by-case analysis to look at any of their programs that might potentially fit into one of these two buckets, either discriminatory or a financial incentive that would be permissible, and then do the legal analysis to decide which bucket it ultimately falls into.
Yeah, thanks, Matt. And I think from an operational perspective, as you just said, Matt, this area of this regulation is especially gray compared to the rest of the regulation that could be seen as somewhat gray, I'll say. We're waiting for clarification or guidance from the regulators on this in terms of what does it mean, because as you've said and as we've read, one area of the regulation says that you cannot discriminate, whereas just below it says, however, you can charge different prices or offer financial incentives. So I think some things to start thinking about as an organization are, what are you going to do if a consumer opts out of the sale of their data? Will you take a different approach? Will you offer a different level of service? Will you charge because it's free currently? Some things to think about like that. I think that's something that, that's a risk-based approach, but it needs to be thought about as an organization. What if you plan on just allowing the consumer to opt out and not offering any different level of service or charging for service? At that point, it's a moot point. Honor the opt out and move out or move on. However, if you're thinking, well, we do derive a lot of value from selling personal data, when they opt out, we would like to maybe change the level of service or charge a price or offer financial incentives. What will that look like? Is it as simple as offering or moving from a free service to a pay service? An example would be in certain email providers, they offer a level of complimentary storage space. Well, if you opt out of the sale of data, could that ultimately be that you receive less storage space? Or if you operate a music app, sometimes for the free service, there is a certain number of skips that you can take in an hour. What about if you opt out of the sale of data? Could that either decrease the number of skips you have within the hour, or what could that look like? So I think that organizations as well as regulators are analyzing this right now and really determining the approach they're going to take, but that's important to do. And as well, if you are going to charge a different price or offer financial incentives once someone opts out of or, exercises their rights, I'll say, perform an analysis of the value of that sale of data to ensure that the justified price or level of service is, different or can be defended and really matches up to the value that you've lost because that consumer has opted out. And so I would say, or recommend quantifying the value you receive from that consumer's data and then making that reflective in the price point or the financial incentive that you offer. So again, that you have a defendable position if you ever need to discuss this with a regulator or through a private right of action. So next we'll drive most people's favorite topic. We'll dive into the consumer privacy requests or consumer privacy rights. So these are things like right to access and right to be deleted. With that, I'll turn it over back to Matt Sullivan to provide us with an overview of those rights, and then we'll go from there.
Thanks, Matt. And yeah, I think it's safe to say that this is really the meat and potatoes of the statute and what companies view as one of the more, the heavier lift within the different provisions. So we're gonna talk about consumer access requests. I'll just give the high level summary, and then we'll dive into the operational elements to comply. But really, this is triggered when a consumer makes what is a verifiable request. TBD on what that is. That's something that the AG regulations will hopefully shed some light on. But upon receipt of that type of request, a business has to be prepared to provide two distinct types of disclosures. The first is a disclosure on the personal information related to the requesting party that the company has collected. And within that disclosure would be the categories of personal information collected about the consumer, the sources of that information. So for example, if it's all from the consumer directly through a retail transaction, for example, the purposes or how that information is being used, and the third parties, the categories of third parties with whom that data is being shared. Those probably are the easier ones to comply with. The last one here is where things get tricky, and that's that the disclosure must also include the specific pieces of personal information collected. So based on a plain reading, essentially what the statute is requiring is companies to aggregate and compile more personal information about someone just so that they can comply with this request. And then the second type of disclosure is related to the information that is sold or disclosed for a business purpose about that consumer that's made the request. And so this type of disclosure would include the categories of the data collected about the consumer, the categories that are of data that's been sold, or as well as the parties with whom it's been sold, and then the categories of personal information that were disclosed for a business purpose. So as far as the nuts and bolts of complying with this, when a company does receive an access request, they must respond within 45 days of a verifiable consumer request. That period can be extended for up to 90 days, depending on a showing of burden, so the volume of requests or the difficulty of responding within that 45-day period. The response has to include the information that's been either collected or sold or shared for business purpose within the past 12 months. And to the extent that a consumer makes multiple requests, the limit is really 2 times within a 12-month period. There is also a right to deletion, also known as the right to be forgotten within the statute. And so here, upon a verifiable request, a business must delete the personal information that they've collected about a consumer, and as well as instruct their service providers to do the same. Now, with that said, there are a number of exceptions that will exclude a lot of personal data from having to be deleted by a company. And these are really common sense exceptions where if a company is using the personal data to complete a transaction, and in some cases would have to share that data with a third-party service provider, as well as more broadly for other internal uses of that data that align with consumer expectations. So it's not, it's not sending it off to a third party for the company's benefit where the consumer has no idea. So again, if you think about how companies are using data, it may be safe to say that a majority of the information would fall under one of these exceptions. And should a company get a request for deletion, they would not have to comply with that.
Yeah, great overview, Matt. And some things to think about, I think, from the operational perspective as you're building your process and procedure for handling these consumer privacy requests, and some things that we see as hurdles when, when clients are building these processes and procedures. Think about how the process and procedure will vary by department, context of use, applicable exceptions, as Matt has outlined. Right to be deleted, it's a right under this requirement or under this regulation. However, if you need that personal data to complete a transaction or you're detecting security incidents, it could be there is an exception to that right to be deleted. So really, and we'll walk through how to operationalize these requests in a couple slides, but really taking in those requests, validating the consumer is who they say they are, and then reviewing, is it applicable, what data is applicable, some things like that. In the employment sector, as this regulation is currently written, it does apply to your employees that are in California. There are legal requirements to maintain data within the human resources space, but those are different requirements from that as compared to a customer or a non-customer, say someone who has simply gone to your website, requested some information, and then moved on without purchasing anything. Also, if you're within a lawsuit or something like that, there might be a requirement to maintain that data. So I think it just goes to show that these rights are not absolute. They require an analysis and a review to ensure they're applicable. Also, start thinking about how your company is going to get these requests. So obviously on your website, you're going to need to have a phone number and an email address. Is there a self-service portal where your employees or your customers or non-customers could log in and make these types of requests? As Matt has outlined, these can be made twice every 12 months. So it's important to track them. How will you defend that you've honored them and maintain the records of requests? So begin thinking about that as an organization. Some other things to think about. What does it mean to delete personal data? In our world, on the privacy side or in the IT side, that means different things to legislators than it does in IT. If you speak to an individual within the information technology stack, they're going to tell you that personal data can never be deleted. There's always a copy there, whereas the regulators have said, without providing any additional guidance, that data needs to be deleted. So how do we do that? There is guidance from regulators in Europe. For example, the UK ICO or ICO has outlined, what do you do, or do you have to delete data from backups? They have commented that you do need to delete data from backups, but if you can't do it immediately, make it unusable or beyond use, if you will, and not accessible. And so there's some commentary that we can look at, but again, full caveat that is from across the pond there. And it is nice that while we do think the CCPA took some of their thoughts or ideas from GDPR, I think we could leverage some guidance from the regulators in Europe. However, it's something that as an organization or as a company, you need to define as well. Not only that internally, but externally as well. What does it mean for a third party to delete data? Your third parties are likely to have, if you quiz 10 of your third parties, they're likely to have 10 different answers in regard to what delete means to them. So working with them to formalize what the deletion means to you and your company, and when a consumer makes that. And again, think about that. Now, with right to access, think through how you're going to honor this request. So yes, by receiving it, you validate it. Well, how are you going to provide a copy to them? They can request it by mail. You can provide it that way. Also, we've seen some companies, if they have a portal or a login where they can verify the identity, they will compile the information through a right to access request and then provide that personal data through a zip file. Think about how long you're going to maintain that data on your end. LinkedIn provided a really great solution where if you go through their privacy settings, you can request access to your data. They will post that data. It'll be in a zip file in your account, but they only maintain it for 7 days because they don't want to become a personal data repository. That's an opportunity for them to be breached, but also, as we all know, storage can become expensive. So think about how you're going to transfer the personal data to the person or to a different provider. And as well, that personal data must come in a machine readable format. And, I think that can leave you scratching your head occasionally. I think, simply put, what that means is it can't be proprietary language or code or an unusable format. Most companies, when they read that, they, again, start scratching their head a little bit. It's not to overcomplicate it. Just ensure that you provide it in a a reasonable format that's not proprietary to your organization that no other organization or consumer could read. Matt, any thoughts on those two slides before I jump into the operationalizing it slide?
No, I think you've hit on the key points, and on that last one, when we talk about the data must be machine readable and not in a proprietary format, it's really just so that because you referenced that the individual is able to transfer that to another person if they want it. Essentially, that it's to ensure that it's a portable document.
Great, excellent. So moving to the next slide, this is just a neat slide that shows some things to think about. So receive the request, do that within a centralized location. You will have the email address and phone number on your website. Is there any other area that you may think about receiving those requests? Is it through an employee portal or a consumer portal? Track the progress as we've outlined. Review the request. So these are not absolute rights. As Matt has said, you want to verify the identity. What verifiable means, we will hope to learn as this regulation is clarified. But review the request, approve it or deny it, maintain records of the decision-making process. That is extremely important. If you deny a request, you need to have a defendable position of why you denied the request. And so if it's right to be deleted, look to those exceptions that we've already talked about and maintain or document why you've done that. Disposition those and document why, track it. Why is tracking so important? I think this is a lesser thought about area within the process, is ensuring that you are honoring them within the correct time frame, of course. So the 45 days, as Matt has outlined with the 45-day extension, but also consumers are allowed to make these twice every 12 months. So you will occasionally, more than likely, run into a consumer that wants to make these requests more than twice every 12 months. At that point, if it's more than twice, you can decline that request and you'll have a reason why, because you're tracking those holistically as an organization. Record it, obviously, at that point. What was the result? When did the request come in? What did we do? What action did we take? We honored it, we declined it. I would say record really means an audit trail to ensure that you can position yourself with a defendable position. And then verify as well. And what we mean by verify is you have worked very hard over the next year or you will be working hard and, investing in your privacy program to ensure that it's operating like you think it is. Ensure that you have a monitoring and enforcement program in place to monitor that you can honor these consumer privacy rights, that the system is working like you think it is, that you're honoring them within the required time frame. It's within the format that you all set it up as. And then go from there. So you have a defendable position as well. If there was an error in the process, while there isn't per se a safe harbor under this regulation, you could go to the regulators, show them your systems, show them what money you've invested, but also show them that you monitor your program to ensure it's honoring the rights like you thought it was. And there was just an error in the process. So Matt, anything over this slide?
Yeah, just one quick point. So I think on that last one about simulation testing, when I'm advising clients, I use the term stress testing because I've talked with a number of companies that they've got robust procedures in place for GDPR, responding to access requests under the GDPR. And in some cases, they may have a huge presence in the US, but a fairly small presence in the EU. So the process is robust, but it's largely manual. And so they would like to leverage that as much as possible, but they may be looking at a much greater volume of requests. We just don't know yet as far as the number of consumers that are going to be making these types of requests. And so they've got their plan A, which is to maintain a more manual process, but then they are also planning for a plan B, which is more automated in the event that they do get a large volume of requests, so that they can respond, largely within that 45-day period. There is some latitude to go beyond that, but from a compliance standpoint, they would like to keep it within that 45-day period. So, it really is important to, once you have an idea of the type of process you would use for responding to these access requests, that, as Matt said, you do the simulation testing, you stress test it, and make sure you can handle what may be an unanticipated volume at this point.
Yeah, all great points. And so next we will be covering the opt-out requirements under this regulation. So opting out of the sale of data. So Matt, if you could take us through what's required, and then we'll dive into it from there.
Yeah, sounds good. So this is the last of the rights that we're going to talk about, and that is the right to opt out of a sale. And really, this is an operational challenge or process that the companies are going to have to address, because there needs to be, as I mentioned earlier, a do not sell my personal information webpage. That is the opt-out page that company or that individuals will link to from a company's privacy policy, from their website. That link has to appear on every, well, I should say it first, it has to appear on the homepage. Now, as I mentioned, some of the CCPA definitions don't follow our traditional logic of what a homepage would be, or what other terms might be. A homepage is defined as any page where personal information is collected. So, potentially if you're collecting IP address, that could be all pages on your website. So you have to have that link there that says, do not sell my personal information. Someone can click on that, go to a separate page in order to put in their opt-out request. If someone does opt out, the company cannot ask for reauthorization, essentially ask them to re-opt in for at least a year. And then there are also some specific provisions related to youth or children. The provision that's specific to selling information for children under 13, that is consistent with, if you're familiar with COPPA, the Children's Online Privacy Protection Act, you need verifiable parental consent. If you're going to be selling information of children between the ages of 13 and 16, you need opt-in consent from that user before you actually sell that data.
Okay, great. Yeah, excellent. Thank you, Matt. And from this side, I mean, when you have the link on your website, if you're selling personal data, you must have, I'll say in quotes, the link, right? It's a little bit ominous. It has to be, front and center to allow the individual to opt out of the sale of data. So thinking through, and we've talked about this a little bit already, but how will you honor those requests? How will you receive them? It's one thing to have a link on your website, but an actionable, step next would be taking those. How do you ensure that internally you are no longer selling that personal data? How will you track and record that you have a defendable position, that you can prove that you stopped selling that data? That is likely to vary by company, but customizing that and working through that. Also, and we've talked about this a little bit, that it's a gray area, but is opt-down an approach? And what I mean by that is not an opt-out, an atomic opt-out, if you will, but more so the consumer clicks an opt-down or opt-out button, and then they're driven to an opt-down page to say, well, we will no longer sell your data for this. However, you won't receive this level of service, or this purpose for this level of service. That is something right now where in the regulation, it looks like that would not be allowed. However, industry is submitting commentary on what that could look like, and we're likely to receive some clarification. So just keep that in mind, that the opt-down might be an approach when it comes to the opt-out of the sale of data. And then tied closely to the right of equal service. And what we mean by that is, they've opted out. So how are you going to honor it? But then also, will your organization or will your company take any action to convince the consumer to continue to allow the sale? So is that you're moving from a free service to a charged service, or some different option under this regulation that your company might take? So tied very closely to each other, and just thinking through how you're going to do that. Next are just general policy development and updates. And so I'll actually just be taking this just because it's a requirement under the regulation to have a governance layer, but it's a broad requirement, if you will. So we'll go over that. Obviously, it's a new regulation. Some new policy, procedure, and process will be required. Would recommend that if you've undergone a privacy journey, I'll call it, in a different regulation that might have similar requirements, leverage what you can there. You might already have a technology in place that you can leverage, people, institutional knowledge, which is excellent. where you have policies that could be amended or simply updated, there's no real need to reinvent the wheel if you can put it within the context of the privacy regulations that are applicable to you. And certainly, we talk about it next in this presentation, but update the incident response plan. And we'll talk a little bit more about how to do that. And then consider, as you operationalize this and then put the policies and procedures in place, centralized privacy guidelines, if you will, that outline what the requirement is, how your company complies with that requirement, assign responsibility by title to the compliance and the responsibility to the requirement, and then outline under each requirement how you monitor and enforce that program. So building what I'll call, privacy guidelines that really serve as your privacy guide to, operate under within your organization, and certainly something you could share with regulators if need be. So moving on to the breach response area of this regulation, and I think this is one that gets a lot of attention because as currently written, it is the only area of this regulation that has a private right of action. And we're aware that we're running a little bit short on time, so I'll try to keep it higher level through these slides, but please, by all means, chat is available. So ask your questions via that, and we'll try to get to those either during this presentation or following it as well. So I just want to point out a few highlights of the breach response. So something to note, and this is more of a requirement, but the definition of personal data under the breach requirement is actually different from the personal data under the rest of the requirements. The breach area of this regulation actually refers to California's data breach notification statute. And it would include, an individual's first name or first initial, his or her last name in combination with any of the following data there. So, when you're doing your mapping, ensure that those are included and where they reside together so you can determine your scope for breach and whether or not a consumer has a notification, but if a consumer can come to you and say their data has been breached, does it meet personal data? And then operationalizing breach response. Define the personal data within scope. Remember to keep that within the breach area. It's different from personal data as it's defined in the beginning of this regulation. Centralize how you'll receive allegations from consumers. You certainly wouldn't want those going to multiple departments across your organization. Train your employees on how to respond to that and your incident response team on how to handle questions. You need to investigate that. Track the notifications of breach and outcome. And then, of course, if you need to update controls and the consumer, do that where necessary. And then reasonable technical and security controls. Moving through those, it's a vague description. This is not prescriptive. These are regulators. They are not, for the most part, information security professionals. It's really operating under the principles of information security. So confidentiality, integrity, availability, while it's gray and that can lead to some frustration, it also leads to flexibility for your organization. So it's really what your company is comfortable with doing. Is it that you want to operate from an information security framework, or would you be comfortable with operating from something that your information security team has set as a best practice, but not operate from that formal framework as is? And so next, and again, knowing that we're short on time, we can move to Matt to give us an update on how the CCPA stands today, and then some other state laws to look out for coming down the pipeline.
Yeah, thanks, Matt. And we wanted to include this in here just to give you the full picture of what we can expect over the next year. As I mentioned at the outset, we do expect some changes to take place to the statute, and we've got our two parallel tracks that are underway right now. The California Assembly has conducted a public hearing to solicit input about possible changes to the statute. The primary advocate in the legislature is really adamant that any changes that are made, that it maintains the level of rights that are currently within the statute, and that the changes really be more surgical and precise to fix more administrative issues with the language or with the provisions. So it's unclear what type of relief businesses might get from those changes. Similarly, the Attorney General's office is working on their regulations that they are required to implement under the statute. They've conducted a series of public forums and collected comments from industry and the public. That comment period ended on March 8th. We don't know when we're going to see the actual final regulations. This is a big lift for them. And one thing that very interesting development is that new amendments were proposed to the CCPA. They were backed by the Attorney General, and it would expand the private right of action, not just to far beyond data breach, but to any provision under the CCPA. So that's very troublesome. If it were to be adopted, it might take the AG off the hook from having to enforce, and that may be why they are behind it. But it would open up a huge can of worms in terms of plaintiffs' attorneys bringing lawsuits for technical violations of the statute. So moving on, unfortunately, the CCPA is not the only law that we have to be concerned with. There are a number of state privacy bills that are working through the state legislatures that really look like CCPA copycats. No state wants to be viewed as soft on consumer privacy, so we may continue to see these pop up. Some are near cut and paste jobs of the CCPA. Others have provisions that go beyond the terms in the current statute. So Massachusetts example already has a broad, it basically has the same provisions in the CCPA, but a very broad private right of action. North Dakota is another example of a law that would just cause all kinds of problems for businesses, where you would need prior express written consent for any sharing of information. So that includes for just providing the service. You would have to get express written consent from the consumer to do that. And then Washington State has a law that is more GDPR-like than CCPA-like, but this is one to watch because it's cleared the state Senate and is moving through the legislative process. And you know, if I were to give it odds, it's got a reasonable chance of making it into law. So these are all bills at this point, but something that every company should keep an eye on. And then lastly, what does this mean at the federal level? So we've probably seen more momentum for federal privacy law than at any time, certainly recently, maybe since there was an effort to have a standard data breach notification law years back, which never happened. But there have been a number of hearings. There are already some sticking points that are shaping up. One is around preemption, as to whether or not a federal privacy law should preempt these state laws that I just spoke of, including the CCPA. That is unclear at this point how the sides are going to resolve that issue. So this is going to take a big bipartisan effort. The fact that we have the hearings going on right now is a good thing, but still too early to tell how this ultimately will shake out. But again, along with tracking what's happening on the state level, I would encourage, I know Matt would encourage every company to keep an eye on what's going on at the federal level as well.
That was a great overview of what's occurring, you know, at the kind of the changes under CCPA and at the state level, that there are a lot of copycat regulations that have been proposed, as well as at the federal level. And it's just, this is something that's very popular politically as well. So something to keep an eye on, as you've stated. So, and I think we're ready to move on actually to the questions point. So at this point, we will take questions from the chat pane as we can and get you some answers on that. And then if you, moving forward to our contact us slide, if you have any questions directly, please reach out. Feel free to email or call us with any questions that you have about the CCPA or any other privacy regulations. Well, thanks everybody for attending. I know we covered a lot of ground there, including the background on the CCPA, operational, things to come, things to look out for. We also had some really great questions in the chat, and I hope that we got to most of you. Here's our contact information. So if anyone has any additional questions outside of what we've handled via chat or what we've handled via what we've handled via the chat pane or what we'll handle, live here shortly, please let us know. Also, I know we covered a lot and data mapping came up a lot during that presentation. We will be hosting a presentation or a webinar on May 15th at 2 p.m. Eastern to cover a little more into the data mapping. We've talked about that there's no silver bullet for it, but we'll cover, things to consider, solutions, things like that to go over, and just things to think about, even though you've been through the GDPR. If you have been through the GDPR journey, things to think about uniquely around CCPA. And if you haven't done the GDPR or data mapping journey, things to think about from scratch. So I think you'll find that very beneficial. So just to go over a few of the questions that were maybe a little more comprehensive than what we could handle in the chat. The first one would be, so we are to record the management of the PI, but by recording it, if the consumer requested deletion, aren't we in violation since we will still be recording it? How do we manage it? Wouldn't we need to track it by name of the person? I think that really is speaking to how do you prove if someone has requested that their data be deleted, how do you prove to a regulator that you deleted their data without maintaining some of that data or proof of compliance? And there are a lot of different strategic approaches towards that, including I think I saw it, a member in the chat function say that once they delete the majority of the information, but they might maintain or segment what they, proof of that deletion in an encrypted file or something like that. But yeah, that's kind of the chicken or the egg, right? You have personal data, you receive a request to delete that data, but you do have to maintain a record of deleting the data. So, it varies by organization really how you prove that and how you work through that. Another one, if you get the right to be forgotten request from a tool, do you confirm deletion to the individual? We have seen some of our clients getting these types of requests. There are solutions out there that will crawl your social media sites, your email, get an idea of the providers that a consumer is working with, and then send a right to be deleted or a deletion request to all those providers. I think the key point under CCPA and GDPR even is that that's a verifiable request, and whether or not you feel as an organization you can verify that request is kind of the action you need to take with it. How will the CCPA view the vendor relationship that a public company has, i.e. suppliers to the company? So that will really depend. You have to define what the business is and then what a third party is and what a service provider is. That's how they'll view those. Likely, if you qualify that or you qualify your vendors as a third party, that could constitute selling, just given how broad that definition is. And if they're a service provider, that could constitute sharing. So all of those will drive notice requirements as well as whether or not you need to honor that request to stop selling the data. And then would a for-profit company acting as an agent for a local government entity have to comply? The answer is, and I, consultant answer here, but it depends. And I think that depends on, the contract as well as what services you're performing on behalf of that nonprofit and whether you're a third party or a service provider. Thanks. And then one additional question just came in. Any expectation that banks may get federal preemption from this state law issue? Honestly, that's just yet to be determined. I don't think we can answer that at this point with any, conclusive evidence of that type of exemption. And with that, again, thank you all for joining. And we will, just a quick, another housekeeping. Yes, we will send out an email with the slide deck as well as a link to the audio for this presentation for those of you that are still on the line. So thanks again for attending.